The first thing that I always mention to people is that Sharia already has a great impact on American law, and people don't even know it. The founding documents of this country refer to concepts that are completely Muslim in origin, that have nothing to do with the continental or Roman civil law. So in Europe, in the mainland of Europe, there is a kind of a common legal code and common body of precedents that Europeans base their law off of. It's called civil law. Civil law is basically what the different countries of Europe inherited from Roman law after the breakup of the Roman Empire. So you see that the legal traditions of France, of places like Germany, places like Italy, of these types of places, their laws are based on European civil law, and there's quite a bit of similarity between them. England, however, doesn't run on civil law. England runs on something they call common law. For those of you who understand common law is, again, like civil law, is a similar and shared set of legal practices, traditions, and precedents that are shared between the people of the mainland of Europe. England has a completely separate system, and the American system is based on the back of what? Of common law. So for example, in America, if a man and a woman live together for 7 years in the state of Washington, I don't know what the law is in the state of Wisconsin or in Illinois, but in the state of Washington, if a man and a woman live together for 7 years or more, the state will consider them to have been married even if they never got a marriage certificate or a marriage license, and they will refer to it as a common law marriage. As a common law marriage, meaning that based on this kind of set of precedents and traditions, legal traditions, that we refer to as the common law, whatever they have, agreement or arrangement they must have some arrangement because they've been in it for 7 years. It's a common law marriage. So the person is married, common law marriage, right? So common law is this, it's a thing that we refer to, right? That if there is, all other things being equal, there are certain sets of precedents that are universally accepted through English law, and then in some fashion American law as well. What's the difference between common law and civil law? Why is it that England has a different body of precedents and traditions, legally speaking, than the European continent? Is it that England was never ruled by the Roman Empire? No, in fact, England was ruled by the Roman Empire for several centuries. And then the Romans retreated and left it. And then afterward, it will be, quote unquote, civilized again by a different people, by the Normans. At least according to popular narrative in England. Obviously, Anglo-Saxons may have something to disagree with about that, but at any rate, the difference between common law and civil law is, there are many differences, but one of the main differences is based on what? Based on the fact that the modern monarchy of England is from where? You guys know anything? That Battle of Hastings, right? Normandy. There's a place in France called Normandy. There's a place in France called Normandy, right? Norman means north, a person from the north, right? So who are the Normans? This is like a huge family, a huge aristocratic class, if you will. And they have empire, they have states all over the place, right? So one of their states is where? It's in all places, Sicily. Sicily, in Arabic, Saqiliya, right? The island of Sicily was actually ruled by the Muslims for centuries. And people don't know that. People oftentimes will refer to Muslim rule in Europe by talking about Andalusia, by talking about Spain. But actually, economically, the lands in Sicily were more prosperous and more productive. And for those a couple of centuries that the Muslims ruled over Sicily, they had absolute renaissance. It was something that was really beautiful in terms of not only economic benefit, but also intellectual benefit. Did you know that the first substantive commentary on Sahih Muslim was written by a Maliki Shaykh by the name of Imam al-Mazari? Mazari is a muhaqqiq of the Maliki madhab. He's a Sicilian. The Muslims actually came to Sicily, and the reason that they were so successful over there, or one of the many reasons they were so successful over there, is they overthrew the feudal system and actually let the peasant commoners own the land that they worked. Therefore giving them incentive, right, for our Republican friends, giving them incentive to what? Work harder, because they're going to earn the money from their increased production. And it absolutely blew all of the land production statistics off the chart based when compared against the productivity of agricultural land on mainland Europe, because people in mainland Europe, commoners, were held as serfs, basically as slaves of the noble class. And so what happens is what? Is that this rule in Muslim Sicily was ended by a Norman knight. A Norman knight who is commissioned by the Pope to kick the infidels, the Muslims, to kick the infidels out of Sicily. And so there is a Norman king by the name of Roger, who will take a Norman army and they will sail onto Sicily, and they will fight the Muslims in battle in several different places, and they will militarily overwhelm them, and they will end the Muslim rule over Sicily. But Roger is an interesting person. Roger, what does he do? He's not like the Spanish kings of Castilla, of Castile and Leon, and of Aragon. He's not like them, in the sense that he has some sort of blind and bigoted hatred against the Muslims. He's only doing this out of some maybe lukewarm religious conviction, probably more for economic and political gain. So when he becomes the king of Sicily, what does he do? He'll learn Arabic, he will read the books of the Muslims, he will read the Quran, he will read the Hadith of the Prophet ﷺ, he will learn the Sharia in a way perhaps nobody in this room will ever have the tawfiq of doing. They say that he used to know Arabic so well that he used to compose his own poetry in the Arabic language. We barely know how to even read poetry that's written in front of us properly. He used to compose his own poetry in the Arabic language, and he was so impressed with the civilization that the Muslims built in Sicily. Not only did he give an amnesty that the Muslims can live and practice as they wish to, he hired many of the Muslims that were functionaries in the Sicilian government to work for him, giving him also the benefits that the mainland Europe was missing out on. And he also adopted and incorporated certain rules of the Sharia, especially regarding the way debts are treated and the way certain sales are affected. Because the Muslims have this ability to trade, right, from classical times over a large expanse of geographical land. So a check that's written in Baghdad can be good in Morocco, or it's good in Indonesia, which is not even the case in the modern economic system, much less in classical times where they lacked the technology to effect such transactions, because it all ran on trust. But he liked these systems of hawalas, of transferring debts and of buying and trading and solving certain issues of liquidity. And the Normans had a huge empire. So imagine this, right? So somebody is ruling in Normandy in France, somebody is in England, somebody is going to go on the Crusades and go this way, somebody is going to go that way, and they're all one empire, and they have to affect all of this trade. So they learn a lot of these things from the Muslims, and they adopt these things into their own law. And that's one of the key points where English common law and what will become English common law diverges from what? From the continental civil law. That in America, we don't have an Islamic court that we've set up. When I say Islamic court, I'm not talking about taking over the federal building downtown. I'm saying at least for our civil matters and our personal matters and our disputes between one another, a dispute between husband and wife and all of these things, we don't have something like this set up. This is one of the long laundry lists of things that the Muslim community needs to get around to. And in order to do that, you need to train people who are technically proficient, not somebody who can give a moving talk in front of a bunch of people that will make them cry and make them make tawbah, or something very entertaining, or something that will maybe be more appropriate for an ISNA convention or whatnot. We need people who are technically proficient in the law. So what do they say? They say, in the absence of anyone who's a faqih, somebody who's technically proficient in the law, you can appoint a council of 40 people, which is, according to a very popular opinion, what they refer to as al-jam al-ghafir, right? A group of people that, if they're upright people and they practice their deen and they're God-fearing people and they're people who do what Allah has made fard on them and abstain from the haram, etc., that number of people is enough, that if they come together and they make dua and they're sincere to Allah Ta'ala, they make dua that Allah Ta'ala show them what's right, Allah Ta'ala won't send them astray. That those 40 people can make decisions on behalf of a judge that's technically proficient in the law, and their verdict will take the place of the verdict of that judge, under the principle of the Sunnah of the Prophet ﷺ, مَا لَا يُدْرَكُ كُلُّهُ لَا يُتْرَكُ كُلُّهُ. The thing that cannot be completely attained also shouldn't be left completely either. So this council of 40 people that will stand in the place of a judge is then adopted by whom? It's adopted by the Normans into civil law. That's how you receive the concept of trial by jury, something that is originally absent, into common law. That's how you receive the concept of trial by jury, something that's totally absent from continental civil law. So if you have a problem with Sharia, go amend the constitution and throw out trial by jury. Go through out the laws you have regarding the protection of debtors in bankruptcy. Go through out all of these things, which it's very easily demonstrable that these are concepts that are not natively developed by Europeans or by Englishmen or by Americans or by the Normans. Rather, they are very demonstrably pulled from Islamic law and adopted into a European law because a wise man will take wisdom from wherever it comes. And if you want to kind of call my bluff on this one, you think that this guy, mashallah, whenever you listen to a Muslim talk, all of a sudden Muslims discovered America, Muslims invented the airplane, Muslims were the first ones to the moon. And there's some people like that. So, if you're wary about it, I can understand where you're coming from, because I've heard a lot of those kind of nonsense talks also myself. There's a Christian Lebanese scholar, actually not Lebanese, I should say, there's a Christian Palestinian scholar, his name is George Maqdisi. I don't know if he's even alive anymore or not. George is spelled George, and Maqdisi is spelled with a K, not with a Q, right? Makdisi. George Maqdisi. He wrote a paper about Islam and the origins of common law. The paper you can find, I think, for free on the internet. I don't know if it's like legally for free, but I see that there are places that you can find it for free on the internet. You can read it on your own, come to your own conclusions, inshallah. But it's written by a non-Muslim, an academian, somebody who has a PhD and all of these other things. So if you think that this is just some bearded guy who's trying to give us a Islam invented everything speech again, well, you can go look it up and see for yourself. African American people, out of all people, need to understand why the nasab is important. Why is it that you have African American people in America, someone's last name Jenkins, someone's last name Jones, someone's last name is whatever, this, that, or the other thing? That's not your forefather's last name. Why? Because they stole your forefathers' last names from you. They stole the names of your people, the name of your tribe, the names of your fathers, and the names of your mothers from you. Because they knew if a person doesn't know who they are, it's easier to convince that person that they're not a human being. If they don't know what their nasab is, they don't know where they belong in the family tree of mankind.